Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. All right, we were talking before the break, and we got the one caller, by the way, Ryan, about the difference between government and private. And again, Russ jumped in there, and I want to stress that because it was an excellent point. It doesn't hurt to take a look at the plan documents. This is where, we do the same thing when it comes to 401ks and retirement plans. Sometimes, custodial agreements, we want to look at them and see what they actually say. So if a company's plan, they're dealing with the pension, there may be language in there that Russ had in fact had experience with this, where with a private company where they were able to in fact get a pension payout. So again, doesn't hurt if this is a sizable amount of money. Yeah, let's doesn't hurt to get that, to consult with Russ and maybe get some help with that. We got a couple of callers, so I'm going to jump on there first and then we'll get back into it. Tim, welcome to the Retirement Report.
Yes, my question was, if you have an account, like a bank account, like say a brokerage account with a bank,
yes,
and they've set it up to where upon death it pays to a certain person, would their basis then become, when they inherit that, the value at the time of the death, or would going that way versus through a will, do you lose that upstep in the basis?
Okay, whether you have a will or a revocable trust, and you're talking about a brokerage account that has, let's say, highly appreciable assets such as stocks or mutual funds in it, then yes, when that person passes, they're going to get a step up in basis. That step up in basis means that the value is going to be that of the date of death, or when they inherit, and then that established, so whatever the value is at that time, if they were to sell it, they'd have no tax consequence. If they held on to it, they've now raised that basis to be the value at that time. This can come into play in today, where we are more likely to see that. There have been times in the past where you can see losses and stuff in these situations. But yes, in answer to your question, they would get a step up in basis, and you can do that with a will or with a trust. The exception we were talking about earlier about an irrevocable trust, of course, is where, depending on the language there, and this is what Russ was talking about. You could, if it was set up in an let me ask you this, Tim. On your situation, is it being passed through by will or trust?
Neither. It's the bank is just put on the account.
Just that payable on death.
Upon death, it goes to this person.
Okay, so this is not
brokerage account.
Okay, it's not an IRA or a retirement account.
It's a straight brokerage account, not
so
an IRA.
Yeah, no tax issues on step up there anyway. But all right, yeah, one of the downsides, and this with payable on death or transfer on death clauses, is that they're very limiting. For one thing, what happens if something happens to the person that's listed on there? So they're again doing the estate plan up with a will or a trust. You're not going to lose anything, and there's a whole lot of things you could gain with regard to taking into mind different other things that could happen. In other words,
the person is about 97 years old, and they put that on there to transfer to her daughter upon death, and she's in pretty bad shape.
Okay. So yes, here again, and I hate to. Well, I don't hate to. This is real important. One of the areas that and you mentioned she's 97 and it's very difficult. Does the daughter have power of attorney for mom?
Yes.
All right. I don't know how large the assets are here, but this would be another area where daughter may want to get with Russ as an example and talk about setting up a trust that would benefit daughter. Okay, and if with power of attorney, she would be able to do that for mom. Okay, so she can get that structured now, where she's still going to get the step up, she's still going to be protected with regard to taxes, but she can get some asset protection features in place that could be a tremendous benefit to her. So this might be a great time for her to come in. In fact, I'm going to throw it on the screen again, 615-376-5325. Call the office. We can get you set up where you can talk to Russ. It's not going to cost you anything. Find out what your options are. There may be some tremendous benefits that could be had with some quick estate planning work to be done. So again, 615-376, there's the number on the screen for you. Give us a call. We'll get you set up, get you in as quick as we can. And, again, least weigh your options. You may not want to do anything, but if depending on the size of the assets, the asset protection features you could set in place right now are tremendous. And with her power of attorney, she could accomplish that.
Okay, thank you.
All right, you're welcome. Take care. Okay, and we've got another caller. This is Clark, I believe. Clark, welcome to the Retirement Report.
Yeah, I had did some, went to a lawyer and drawed up some paperwork, and I'm putting everything into my grandkids' name.
Right.
I am divorced, and he drew up a estate, but it says trust, will and trust as well.
Okay.
So is that the right one to take?
Well,
So I need to put it all in the estate.
okay. Here's what you're looking at. It sounds like, at least it could go either way, but I'm going to take a stab here. You've got a revocable living trust with a pour over will. Does that sound like right?
Sounds about right.
Now the issue is not is that the right one. It's what's the language in it. So you can have, let's say, the trust and the will underneath it is kind of a safety net. And I'm going to let Russ jump in here and talk about this bit. But this, Russ, is, we talk about all the time. And that's what I was saying earlier. I look at people's documents, and I know Russ looks at a lot more than I do. But when I'm looking through, a lot of times it's more to do, is it going to do for you what you want it to do with regard to your grandchildren? And has it taken into consideration their ages, when they're going to receive things? All those kind of questions. Is it in fact going to do what you intend it to do? And that's where the language within the documents is also is as important as, of course, having the right document. You can have the right document, but the language isn't right, it's not going to be the right document.
Yeah, and I probably, just looking at what you want to accomplish, it sounds like you've gone down the right road, starting out with a will and a revocable trust. And then some of the other questions I would ask is, okay, once you do pass away and these assets do pass down to the grandkids, are they going outright? Are they going to stay in a trust format, which I would recommend? Are the grandkids able to handle the money at that point? You want to make sure that the beneficiary designations and the titling is also coordinated with this plan, so that the assets are either titled in the trust or that they pay the trust at the time of your passing. Are the assets going into the trust retirement account assets? Then we have to worry about whether the grandkids' trusts are stretch trusts, or not, so that we can use the grandchild's life expectancy for payout, RMD, required minimum distribution calculation payouts. And so there's a lot of little questions that probably you'll need to have answered if you want to make sure you got it set up like you want.
There's one question that I want. Would probate, would it still have to go into probate to get this stuff solved?
That's an excellent question, and here's another area that the answer is not as straightforward. And the reason is this comes into what we refer to as the funding of the trust. Okay, so let's say you have the trust set up, but now the other part of this is, did you in fact get the assets transferred to where they're titled in the name of the trust? And if it's retirement assets like an IRA, 401k, those kind of things, is the trust structured to be, or set up to be, the beneficiary of the trust? Those are the kind, or the trust set up to be the beneficiary of the retirement account. Sorry. So one of the things there is, if for you to avoid probate, for it to do the things you want it to do and keep your costs minimal and keep it private and all the other benefits that go with that, is the funding. And that's where a lot of times when Russ and I work together, in fact all the time, one of the things there, Russ gets all the documents set up, and then I work with our clients with regard to making sure that the transfers are done, or that things are properly titled, beneficiary designations are up to date. And when we're doing comprehensive plans with my clients, again, the same thing. Because of the type of planning I do, I'm meeting with them on a regular basis, and I'm keeping track to make sure that their beneficiary designations are kept up to date. If they transfer funds around, that we make sure that that they're properly titled, or that the beneficiary designations are done properly as well. So I'm going to, again, Clark, I think you'd be another one that would be, would really benefit from this consultation. So I'm going to throw the number up on the screen again, 615 376-5325. Just call my office. Tess is standing by. She'll get your information. With that, we'll send you out a packet of things. It's basically a checklist for you. It'd be very simple. If you want to do the comprehensive plan, that's great. If you'd just like to get those estate planning documents reviewed and see what's needed to make sure that they're going to do what you want them to do, just get it. Let's see if we can get it up on the screen for you. 615-376-5325. First 10 callers, but Clark, I've written down 3 people's names today, Ryan, Clark, and Tim, that have called in. So even if you're not in the 10, you're going to get in. So just give a call. Tess will get your information. She'll send you out a packet. Mention to her we talked on air and about the estate planning concerns in particular, and we'll make sure we get Russ involved at that appointment as well for you. All right, and then we can review your documents, and it doesn't cost you anything, and let you know, in fact, that it's going to make sure it's going to do exactly what you want it to do. Okay?
Give me that number one more time.
Yes, sir. 615-376-5325. That's to my office. There it is on the screen for you. 615-376-5325. All right. Tess is standby. She'll get your information and she'll take care of you. Okay?
Okay.
All right. I appreciate you. You have a good day.
You too.
Take care. Bye. All right. We're going to take a quick break. When we come back, I want to jump back into utilizing trusts now, for not just on the estate planning, but now we're going to be talking about tax planning, about asset protection, about some of the ways they can be used. And also, just because once you have it set up, getting it reviewed, sometimes life happens, right? And it may need to be changed. Well, that can be done as well. We can amend. We can, as Russ was talking about, we'll come back to that as well. How to decant the trust so that you can create something if life changes in a way and you want to get, you've got highly appreciable assets. What do we want to do? Do we want to pay more taxes than we have to? Absolutely not. So if there are ways, all right, if there are ways that we can work within the laws that we can help you, protect your assets and pay less tax, that's a good thing, right? So join us here. We're going to get into that and more when we return. We'll be right back on the Retirement Report.